All right, hello, folks. This is Jezzy and Sophia's presentation on immigration status, and we hope that you enjoy. All right, before we get started, I'd like to do a digital land acknowledgement statement. Um, the University of Wisconsin-La Crosse occupies the land of the Ho-Chunk people. Chunk people are the original owners of the land who were forcefully removed through forced treaties by the U.S. government. As student affairs professionals and practitioners, it is important to recognize the relationship between colonialism and its impact on higher education. Hence, we must educate ourselves on the impacts and take action to support indigenous communities. I've listed a couple of resources here at the bottom. We have firstnation.org, which is a guide to learn about tribal nations and tribal lands and nations. And we have the Wisconsin also First Nations Native Land Map, which makes you understand which native land you occupy. And we have the DPI.wi.gov, which has indigenous educational resources.
All right, so to begin, we just want to give a brief case summary of what our case is about. So in this situation, we were the directors of admissions at Western Texas State University, where Felix, one of our orientation leaders, was sad about his cousin who wasn't able to attend WTSU. Sylvia, Felix's cousin, is an undocumented student who received a letter from financial aid stating that she is ineligible for financial assistance. Sylvia was also told that she would have to pay out-of-state tuition despite living and growing up in Texas. Um, One thing that was noted on here is that undocumented students are ineligible for federal aid, but they were not certain about in-state tuition. The new director of financial aid came from Georgia State University, and this is important to note as we will get into it later. And then ultimately, the campus climate is hostile towards undocumented students. So as we go through this presentation, we're going to kind of break down different aspects of this case summary to give a full picture and understanding.
So, thinking about a couple of cases that have to do with immigration status, the first one that comes to mind has to be Plyler versus Doe in 1982. So, in 1975, Texas had this education law that allowed the state to withhold from certain local school districts state funds from educating undocumented individuals or educating children of undocumented individuals. So the case was decided with Texas versus a couple of unnamed undocumented children. And so the question to the court was basically, did this law that Texas have, did it violate the equal protection clause of the 14th Amendment? And so the court said yes, it violated the 14th Amendment by severely disadvantaging undocumented students just because they had that status. And also, Texas couldn't prove that this law that they had a compelling state interest. So it's just saying essentially it did not pass the strict scrutiny test. And so what was also interesting was a concurrent opinion that said it would be smart to have a sector of society that is just not and that is just not uneducated because the benefits just outweighs the cost. We also had dissenting opinions which said it would harm the quality of education, but the courts just asked to defer this decision to school policy. So a big implication for this was that it granted the opportunity for undocumented immigrant children to attend public schools, and also those public schools couldn't charge them tuition. So thinking about the second case here is Equal Access versus Merton in 2004. So Virginia had policies of denying admission, or Virginia public schools and colleges had policies of denying admission to enrollment of illegal or undocumented individuals. And so, Equal Access versus Education was this whole organization dedicated to ensuring equal access to education in their name to all individuals, regardless of their status. And so they claim that this Virginia law had violated the supremacy clause of the United States because institutions are allowing state officials to make immigration status determinations, and also they use different standards from the federal government to determine individuals' immigration status. So that's what equal access education was claiming. And so the court determined in this case that the supremacy clause did not stop defendants from adopting or enforcing admission policies that denied admission to undocumented individuals, provided that the defendants used federal immigration status standards to identify which applicants were undocumented individuals. So at the end of the day, the court held that undocumented individuals just lacked the standing to challenge state college admission policies in general. So that was something to learn from that case. And thinking of, I can't really say the name, Nyquist versus Jean Marie. This was a case in 1977. This was about two permanent residents of the United States. That's also a different status. So they're not actually citizens, but they have legal residency. So they tried to apply for financial aid, but they were denied based on the fact that they were not U.S. citizens. So the court ruled that this violated the Equal Protection Clause of the 14th Amendment because citizenship requirement discriminated against them. So at the end of the day, the significance of this was that resident aliens, as they're called, or permanent residents, have the same rights as U.S. citizens as well.
Some additional cases that come to mind are like Elkins versus Monroe of 1978. This came into effect or came into playing with the G4 visa. The G4 visa is what people who are part of, what's the word? Like international embassies or organizations, things like that, they can apply for. In this case, Elkins was the president of a university, and they were suing for dependents of G4 visa holders not being able to receive in-state tuition or benefits. And originally, it was decided that the university said that the intent G4 visa holders could not receive in-state tuition because they were not able to prove that they have domicile in Maryland. And part of the G4 visa process is that it is a non-immigrant intent visa when you first obtain it. But that is just for the primary application process. Things do change and things do happen once you arrive in your destination. That it was then found through the Supreme Court that G4 holders and their dependents have the legal capacity to change domicile in their situation, thus making them able to obtain the in-state benefits. Another court case to mention is Martinez versus the Regents of the University of California of 2008. This kind of plays on as well with the Elkins versus Moreno, but this is involving the AB 540. This provides that students who have attended at least 3 consecutive years of high school in California, graduated from a California school, and meet certain other conditions may attend states and colleges and universities at the same rate that is charged to state residents. So what happened here was somebody tried to reverse the AB 540, but it was denied. And then also the appeal was denied as well, stating that they do have these qualifications and it is part of their visa process that they are able to follow these state laws and obtain that rate. Now, DeVries versus the University of California of 2016. DeVries was a taxpayer in California who had issues and argued that there was no state law or statute to make undocumented immigrants eligible for post-secondary education. He was stating that AB 540 and I think it was AB 131 were not state laws, and that school policies were not state laws, and therefore making people ineligible to receive these benefits. Then the court came back and said policies established by regions as a matter of internal regulation may enjoy a status equivalent to that of state statutes. So with that being in place, the court sided with the regents, and then the Supreme Court refused a hearing for a appeal. So therefore, AB 540 stands, and undocumented immigrants can obtain in-state benefits and tuition.
All right, so thinking about laws here that pertain to immigration status, we have the IIRIRA, which is the Legal Immigration Reform and Immigrant Responsibility Act of Section 5. So this requires proof of identity for any certain public assistance. So such as, for example, employment eligibility, you need a I-9 verification to show that you're eligible for employment. For example, myself, I remember when I graduated in 2021, 20 could start working in the summer, I needed to verify, do a I-9 verification, for example, to prove that I still had employment eligibility in the United States. The proof can also be your I-20 as well, which is another international document that I have as well to show that I'm eligible to work in the United States. So if employers don't ask for employment eligibility from individuals, they can face at the end of the day. So the Illegal Immigration Reform Act, especially Section 5, requires proof of identity for certain public assistance. And secondly, we have the PORA Act of 1996. This is the Personal Responsibility and Work Opportunity Reconciliation Act. So this prevents immigrants from receiving federal means tested public benefits for 5 years after they attain lawfully present status, which is crazy. So the benefits include, among other things, food assistance under Supplemental Nutrition Assistance Program, the SNAP, or health insurance under Medicaid. So they have to wait for 5 years before they attain any of those benefits. So lastly, we have the DACA, which is the Deferred Action for Childhood Arrivals, and so which Sylvia is most likely a DACA student. So it was a policy created in 2012 for individuals who entered the United States unlawfully as children. So they're also referred to as the Dreamers. So the program does not grant them official legal status or a pathway to citizenship, but it does allow them to have a driver's license, a social security, and also a work permit. And also under the DACA laws, individuals are excluded from accessing federal benefits entirely. Despite also being lawful present immigrants, they have a driver's license, social security, work permit, but still they're unable to access all of these federal benefits. So this is possibly why Sylvia couldn't get financial aid at the institution.
All right, and then a couple more laws to talk about here. The first one would be the DREAM Act of 2021. This bill directs the Department of Homeland Security to cancel the removal and grant lawful permanent residence status to non-citizens who are inadmissible or deportable or as in temporary protected status if they meet 4 criteria. And this is important because with the DREAM Act and granting them permanent resident status, students will be eligible for more access to education and benefits and aid to help them make that education attainable. Another law would be the U.S. Citizens Act of 2021. This is a bill that is still being worked on, I believe. This bill would provide a pathway to citizenship for the undocumented population. And it kind of like shortcut it to 8 years instead of possibly a lifetime of trying to get there. So it addresses like some of the root causes of forced migration, as well as additional rights for immigrant workers. Once again, being able to obtain that permanent residence or that green card would give families and students a lot more accessibility and opportunity to pursue a higher education. And then Lift the Bar Act, this one is still being reviewed and altered and things like that. So finding a little information was a little tricky. But the key provision, this act would repeal key provisions of PRWRA and what all entails with that. One of the ones that I really want to mention on that, or key aspects of that, would be the restrict of lawfully present immigrants' eligibility for federal assistance programs, such as like aid for education and just being able to exist. So this is something that is really important. And then it redefines qualified non-citizens. Instead of using the word as aliens, using non-citizens instead. And it provides individuals who have access to the Affordable Care Act health insurance, and under current rules will not lose access to affordable coverage if they remain ineligible for Medicaid. So having that access to healthcare is also really important and something that a lot of our non-citizens do not always have access to because they don't have documentation to show that. So when looking at how to respond to Sylvia's case, one thing to take a look at is the Senate Bill 1528. It's the TAFSA bill, which is the Texas Application for State Financial Aid. This bill is stating that you are eligible to receive state financial aid by completion of the Texas application. And there are requirements to be eligible for this, which fall in line with the AB, what was it? It was AB 540. And so, for example, you must have a high school diploma or equivalent in the state of Texas. You must have lived in Texas for 12 months before entering at this college, and maintaining 6 credit hours, things like that. So we would set up a meeting with Felix and Sylvia. Maybe not even Felix, because it's personal information, honestly. So probably just set up a meeting with Sylvia, go through the information. If she's okay with Felix being there, then you can bring him in. But as this pertains to Felix, be like, hey, this might be an opportunity for you. And then also set up a meeting with the financial aid director and Sylvia. As I have looked up in this presentation earlier, there are also additional items to address here. For example, I know that while not eligible for federal aid, Texas does offer state aid, which is what the TAFSA is. But then also, as I said before, the new director of financial aid came from Georgia. Georgia is a state that does not allow for non-citizen students to apply for state aid. So the director mentioning to Sylvia that she's not ineligible for state aid is incorrect, and he is basing it off of a different state policies and is not up to date on what Texas requires. So there's some issues with that. So having a meeting between perhaps just us and then the financial aid director first, and then having Sylvia join later, just to get that discussion out of the way first would be most beneficial. And then what else was I going to say? So state aid varies state to state, and Texas is one of the ones that do offer in-state. So to be able to accurately help Sylvia, especially in an area that is not ours as admissions, but we work closely with financial aid. It is something that needs to be addressed so that way students aren't in the same place of stress that Sylvia would be put in, and then we don't have these problems down the future, so long as they fill out the TASFA and continue on with that.
So we thought that we'd also respond to Felix talking about how um, the campus just feels really hard for undocumented students like himself and also Sylvia to be. So, he talked about being in the dining halls, the residence halls, and even in the classroom. It just feels like a chilly climate because of the immigration pressures, even given the political climate in the U.S. Just they don't feel safe as undocumented students. So how can we respond as student affairs professionals to the chilling climate for undocumented students? So this really cool article that I found by Klein et al. So it's basically talking about learning from undocumented students, their testimonies, and strategies to support and resist. So I really love the first point they made here, um, which was having self-awareness. So the first step for folks to do, student affairs professionals, also faculty, have that self-awareness about yourself. Think about your privileges and think about it's just having empathy as well. Just understanding and not being in that situation of that student, putting yourself in that situation and seeing what it's going to be like. And so with self-awareness, you also build relationships with students around you. So um, having that self-awareness is key to building relationships with not only just undocumented students, but any type of student at the end of the day. So, secondly, the next step that they suggested for folks to take would be educating staff and students about about students with undocumented status. So it's really important to educate our staff so they know the differences between undocumented immigrants, refugees, legal permanent residents, like I was saying, um, and also just know the history of immigration and the current policies and program actions and how they affect students and families. Understanding things like whatever the ICE, who's ICE, what can they do, what can they not do. Teaching families about their rights and helping students plan for worst case scenarios such as deportation. So it's good to educate ourselves, also ourselves as student affairs professionals and also faculty about different undocumented statuses of individuals. Um, Secondly, or thirdly, it's also good to include undocumented students in college programs. It really is just not assuming that there isn't any undocumented student. It's just always be prepared and be ready. So make those resources available. Colleges must make information about programs that lead to certification, for example, for undocumented students, so they can determine their future. Also, they need to know about the statuses. This goes along with the second point of education. Know the status of the student. Think about when your work expiration, or I guess when your work permit expires. Thinking about that too and working with them and having them to be, just have that certification at the end of the day so they can fend for themselves. So these are a couple of solutions or ways that we can be better in responding to students with different immigration statuses. Thank you.